morning.
Good morning, Your Honors. May it please the Court. This case concerns public official immunity and not the public duty doctrine, which does not involve immunity at all, but whether there is a duty enforceable in tort. Immunity.
You say it doesn't involve immunity. Hasn't the Court stated that it involved immunity in prior cases?
The public duty doctrine, Your Honor?
Yes.
Well, Your Honor, one case,
Williams,
yes, Your Honor, but that case is really out of step with every other case in which this and any other court has undertaken an analysis of public duty doctrine and public official immunity. For example, in Muthuku Marana, which was decided 2 years after Williams, the court analyzed public duty doctrine without any mention at all of immunity, well, treated them as separate concepts. And in Boyer and in Ashburn, they were also analyzed separately as alternative holdings because they involve different elements. I mean, immunity deals with the issue of whether there could, even if there is a duty, there can be liability. It's immunity from liability, even in the presence of duty and a breach. Whereas public duty deals with the existence of whether there's a duty at all, whether the duty is to the general public or to the individual plaintiff. And repeatedly, this Court has analyzed them as alternative doctrines. They're distinct conceptually and doctrinally. They have different elements. They have different exceptions. The public duty doctrine identifies when a duty exists at all and analyzes whether it's a particular class of individuals and whether it's enforceable in tort. Public official immunity analyzes whether the actor was a public official, whether the actor was engaged in discretionary or ministerial act and decision-making, and whether it was in the scope of the public duties or official duties. And if you look at, for example, sections 509 and 507 of the Courts and Judicial Proceedings article, which codify public official immunity for certain officials, there's no mention of special relationships or duties, and there's no exception for a special relationship. The only exception is that it doesn't cover, malicious acts or ministerial acts. Those are the exceptions to, and it has to be a public official, of course. Those are the exceptions that deal with the public official immunity. And so it would be very unusual for this Court to have established yet another exception that would only apply to common law public official immunity without any analysis as to why that should be, and wouldn't apply to the statutory public official immunity. And if you look at Williams, it draws from cases involving the public duty doctrine, and it draws from cases involving public official immunity without distinguishing between the two. For example, Williams says that the public duty doctrine doesn't apply to discretionary to ministerial acts. Well, that's inaccurate. The public duty doctrine, one can know a public duty and have it be a ministerial duty. It's not restricted to discretionary duties. And there are a number of cases that Williams relied on, two in particular that Williams relied on, Williams versus State of California, and a case from the State of Washington called Castanez, I think it was. They're both cited in that decision, and both of them very clearly draw the distinction between the immunity concepts of public official immunity and the public duty doctrine, and point out that you don't even get to duty if you have immunity. And if you have, you can have a duty and breach it. Many public officials who've been given public official immunity have had a duty that's been breached, and it's been a public duty. And then if you go back to Clark versus Furling, which is one of the early cases, 1959, talking about correctional officials, pointing out that it's a public duty for the care and keeping of inmates, and that even where the officer is aware of some particular possibility or threat to the inmate, unless it rises to the level of malice, his failure to take action to protect the inmate he's immune from recovery for that. And so
on that point, I recall that the jury had found that Mr. Cooper, Officer Cooper, Sergeant Cooper, had acted with gross negligence. The circuit court judge granted judgment NOV on that point, and the Court of Special Appeals disagreed.
Yes, Your Honor.
In your analysis of the case, does the determination of gross negligence figure?
Talking about the public, talking about the issue that I'm now discussing rather than this.
Yes.
No, Your Honor, because this court has consistently stated that only malice negates public official immunity. The two statutory provisions only have exceptions for malice. This court has consistently interpreted them to be the same. And we explain in our brief how all of the cases, when discussing the elements of the public official immunity, state an exception only for malice. And to the extent that in a wrapping up paragraph, there may have been a combination discussion of Maryland Tort Claims Act immunity and public official immunity where gross negligence was mentioned because of the presence of the Maryland Tort Claims Act discussion. In no way has this court ever stated that gross negligence negates public official immunity. There's no holding.
Have we ever stated that it doesn't?
Yes, Your Honor.
Which case
it's only malice. Consistently, that it's only malice that.
Have we ever had a case
where it was the actual holding?
Yes.
I don't recall off the which case it is that that says that where it was actually argued and presented, Your Honor. But in each of the cases where there was allegations of negligence, gross negligence, and malice in the context of public official immunity, the court stated over and over again that only malice, that public officials are immune for non-malicious acts, and only non-malicious acts. So, and that it's actual malice, it's not the implied malice that gross negligence is described. So,
can I take you back to Williams for a minute?
Yes, Your Honor.
Do any of the subsequent cases disapprove of the language in Williams which treats the public duty doctrine the same as an immunity?
No, Your Honor. They either don't mention it or, and then Livesay repeats it in sort of a general overview of the law, repeats the statement from Williams that a special relationship can negate that immunity. But
it hasn't disappeared from our case law.
Well, it's really, Williams is aberrational in this court's case law. As I said, every other time this court has discussed the concepts of public duty doctrine and immunity, the court has recognized that there's a fundamental difference between duty and immunity. One can have a duty and have immunity. I mean, state employees under the Tort Claims Act, they have duties and they have immunity.
I can understand how there could be a difference. I'm just trying to figure out whether our cases have treated them as the same or not.
The only case that's treated, that has sort of intertwined them and mixed the elements together and drawn on both lines of cases to discuss them is Williams. All Livesay did was repeat the statement from Williams without undertaking any analysis. And as we said in our reply brief, there are a number of out-of-state cases that actually tackle this issue head-on as to whether they should be analyzed the way they were in Williams, whether they can be sort of all the elements mixed together and have, a special relationship exception where there's immunity, and have rejected that and have said that you have to look at duty and immunity separately, that they're two different doctrines, and that they have different elements and exceptions. And here, if you're going to take public official immunity and have this exception for the common law version, then you have a disconnect between the statutory public official immunity and the common law, which is applicable to like, for example, the Maryland State Police will be treated differently than the local police. So that, based on what seems to be a conflation of the doctrines in Williams, an inadvertent conflation, that would be a highly unusual approach to take. It would be unique in the country, because no other case that I'm aware of has analyzed the two doctrines and mixed them together in that fashion.
Do you concede in this situation that there was a duty owed by Sergeant Cooper to the inmates on the bus?
Well, as this court stated in Clark, it's a public duty, the care and keeping of inmates. The cases have recognized that there can, under particular circumstances, be a special relationship created that is an exception to the public duty doctrine when dealing with inmates. And there are several cases that have held that. So, for example,
I guess what I'm really asking you, do you concede that there was a special relationship between Cooper and the others on the bus?
No, Your Honor.
So no duty was owed under these circumstances?
No, Your Honor. There's a public duty, and then if there had been information, if Sergeant Cooper had information that there was a special danger or threat posed by Mr. Johns to Mr. Parker, then there would have been a duty, a special duty. But still, the cases hold that even where there is a special duty, a public official has public official immunity for discretionary decision-making regarding, for example, inmate safety. And we cited several cases in our brief that hold that, out-of-state cases, that hold that in making these decisions about how to manage safety of the institutions and safety of inmates, that public officials are engaged in, public duties, but they're also engaged in discretionary decision-making for which they have public official immunity. And
well, all that's, I understand all of what you're saying in theory. Let's relate the doctrines that you've discussed to the facts of this case, which, as evidently found by the judge here, the jury, they're fairly extreme. We have Sergeant Cooper, and you'll correct me if I have any of this wrong. First of all, he had the overall responsibility for the bus. He was supervising the
yes, Your Honor, he was the officer in charge on the bus.
And he was located within a matter of, 7 feet?
7 feet, Your Honor, in a locked security cage in the rear of the bus.
Was he and at least one other officer shining flashlights? Tell me where that was.
Well, what happened, Your Honor, was, and all the testimony, all the accounts from the inmates, from the officers, it was all consistent that the ride up, the ride up was uneventful. This was the trip back from Hagerstown, and that
in the middle of the night, early morning hours.
Yeah, it was between 3 and 4 a.m. And that Officer Scott, something drew his attention to the area where Mr. Parker and Mr. Johns were that area of the bus.
Where was Officer Scott located?
He was right next to Sergeant Cooper. They were in the locked security cage at the rear of the bus together. Something caught his attention, and he noticed Mr. Johns changed seats. And so he looked over, and so he was watching, and he saw him change seats, and he couldn't see what he was doing, so he called up to the front of the bus. He told Sergeant Cooper to call up to the front of the bus and ask that the lights be turned on. And the lights came on, and he still couldn't figure out what he was doing, so he and Sergeant Cooper directed their flashlights in from the back, and one of the officers in the front was also shining his flashlight up, and they all of them were saying that they couldn't see what, if anything, was happening. They also evidence from one of the inmates, Mr. Cook, that another inmate was, when the lights came on, he was blocking their view, or deliberately blocking their view. So all of the contemporaneous accounts are consistent from everyone on the bus that Officer Scott and Officer Cooper were trying to see what was happening and were unable to determine what was occurring.
Wasn't there something about lights, internal lights on the bus were out?
4 of the internal lights in the bus were burned out, yes, Your Honor. Did
the evidence reveal how long they had been burned out?
Yeah, the driver testified that he had reported it some days prior to that and that they hadn't been fixed yet.
Was the
But he didn't
evidence,
say how many days it was.
the evidence reveal whether Sergeant Cooper knew that?
No, it does not, Your Honor.
Well, he knew it when,
He knew it while he was on the bus,
when they
but
turned the lights on, these lights didn't come on, but did he know
Well-
before that?
that even if the lights were on, that they were burned out. I don't recall any evidence about that either way, Your Honor.
There's no documentary evidence of when the driver submitted paperwork saying the lights were out?
No, just his testimony that it had been some days before this particular trip.
No protocol for checking all the operating mechanisms in the bus before they loaded it up?
That was the driver's responsibility, and he testified that he did that, that he had checked the bus and searched it, that he did that every time before he took a trip. That was his testimony. But the testimony of all of them, I mean, was consistent that whatever they should have seen, they didn't. And that's why the trial judge and the district judge earlier than that and the administrative law judge all found negligence, because it was inattention. Nothing ever happened on a bus. There'd never been a history of any thing happening on one of these buses. It was they would just go up in the middle of the night and they would come back. And I think all of them had been on this detail for a year at least. Nothing had ever happened.
Which of the officers was the person responsible for the inappropriate chaining of Mr. Johns?
That was Officer Surgeon. That was her responsibility. Was his restraints.
Were the protocols such that any of the other officers were required to check what that officer had done?
There was testimony that the officer in charge should have checked the restraints, double-checked the restraints of every inmate.
And that is Sergeant Cooper.
That is Sergeant Cooper, yes, Your Honor. But again, that's negligent supervision. That's not gross negligence. So, what the Court of Special Appeals pointed to was basically that it was there to be seen and he didn't see it. But again, that's a statement of a negligence standard of care. And so, I think that's why.
Or he saw it and he ignored it.
Well,
That's the real issue.
Well, that's what the plaintiffs say, but there's no evidence of that.
But
The evidence.
When they got to Supermax, they made a decision to go into the bus as a team. So at that point, they knew something pretty serious had gone on the bus.
Well, the evidence was that they went back there because they were concerned about that they might have been planning to attack the officers, I think, or planning something. It was. I guess it was sort of a worry and a concern, but there was just no evidence from inmates, officers, or anyone that anyone had any notion that something so horrible could have occurred. Something that there was such evil on the bus. There was negligence on the bus, some of the experts said, but there was really no basis in the evidence for any of these officers to really know what they were dealing with Mr. Johns. Whatever he'd said in court the day before, they didn't know. They didn't, the sentencing and proceeding had apparently, set him off, and he determined that he was going to take this action, but that was never communicated to them. And he'd been with Mr. Parker the day before, uneventfully. They were laughing and talking together, and the only person who'd expressed any concern about these inmates had been the other inmate who wanted to be in the security cage in the front, because he didn't want to be near any of the Supermax inmates, and all of them he wanted to be separated from. But there was no evidence that Sergeant Cooper should have thought that Mr. Johns posed a danger to Mr. Parker. They were friends, and Mr. Parker was testifying on his behalf. They traveled together uneventfully. There'd been no, warnings or special instructions. This was a routine trip that went horribly, horribly wrong. And, the officers saw something going on during the trip, and they tried to figure out what it was, and they were unable to do so.
Question, maybe simply to satisfy my curiosity. You've mentioned twice that Sergeant Cooper and Officer Scott were in a locked cage
Yes, ma'am.
area at the rear of the bus.
Yes, Your Honor. So even if they...
It seems, explain to me what the protocol is for all that.
Well, the driver had the keys, and they didn't have a key. And so the protocol was that they couldn't get out until the bus stopped, and the driver came around and let them out. So there was, I think, a procedure where the officer in charge should have been in the front with the keys, but he was in the back without the keys. But if he'd been in the front with the keys, he still wouldn't have been able to, he wouldn't have been, able to do anything.
Is there a protocol about moving, before you sit down, was there evidence that we know that Mr. Johns moved over to the other
Yes, Your Honor.
seat? Is there a protocol one way or the other about that,
Well,
allowing the inmates to
They weren't
shift
supposed to move
seats
around on the
around?
bus. There's no doubt about that. I mean, they weren't supposed to be walking around the bus.
Was the testimony of the officers that we didn't observe that happening?
No, what he said is that by the time they got their flashlights directed at him, he was back in his seat and just sitting there looking at the ceiling, looking really relaxed. And so, when they actually had the lights directed at him, it was over, and it was. He had finished, and he didn't move after that or attack after that. And so the next time they were, saw anything was when they actually arrived at the institution.
I might encroach for 15 seconds on your rebuttal now. Was there any testimony that had Mr. Johns been properly secured, he actually couldn't have moved to the other seat?
No, Your Honor. I think the testimony was that if he'd been properly secured, he wouldn't have had the freedom of movement with his arms to be able.
So that's the limitation on the restriction.
Yes, Your Honor. It's the securing of the wrist to the waist chain was the problem. They were too loose, and so he had too much freedom of movement with his arms.
Okay.
Thank you.
Mm-hmm. Mr. Hansel?
Thank you, Your Honor. Good morning, and may it please the Court, it's my great honor to represent the family and estate of Philip Parker and some of the families here with us today, and I thank the Court for your time. I want to start with the question of gross negligence. If this case isn't gross negligence, it can hardly be imagined what would be. This is a situation where the suggestion's been made to this Court that Officer Cooper knew nothing about Mr. Johns. Well, he knew he was an inmate. He knew he was a supermax inmate. His testimony in that regard is at 774 and 775. The warden of this facility testified that supermax inmates are the worst of the worst, are dangerous. There was a prison expert who testified for the plaintiffs that you have to earn your way into that status, that it's not only based on the crime, but you have to repeat your criminal behavior behind bars.
And yet, even supermax prisoners have to go to court.
That's correct, Your Honor.
So what should be the procedure for transporting supermax prisoners to court?
There was an excellent procedure in place, and it wasn't followed. So, for instance,
So that's negligence.
It's gross negligence when you sit and watch this murder take place from 7 feet away. It might be negligence to do what Cooper did and not check the waist chains and allow the freedom of movement. It might be negligence to do what Cooper did and sit in the back instead of the front without the key. It might be negligence not to replace the lights. But when you stand from me to the end of that table in an elevated position with the duty to observe and intervene and watch one man pull another's head up over the back of the seat and choke him.
Let's talk about that, pull the head over the back of the seat. You said that in your brief.
Yes, sir.
Where is it in the testimony?
It's in pages 653 and 655. The testimony was that Johns pulled Parker's head up and over the top of the back of the seat.
Who's
I don't see,
testifying?
I couldn't find that over the back of the seat part.
It's 653 and 655.
E653?
Yes.
Is that testimony from another
Yes,
inmate? who was
it's
on
one.
the bus?
It was either Johns himself or one of the other inmates, and I honestly don't recall which, Your Honor.
Is there any testimony that this was visible to the officers?
The officers said
saw it?
they couldn't see anything. And when asked why it was that they couldn't see anything, and Cooper was given an opportunity to explain it. Was there an inmate in your way? Was it because the light was bad? Was there some other reason? And he said, I have no explanation for why I couldn't see. He offered literally no excuse to the jury why he couldn't see. And not just see, but hear. Because during this struggle, the inmate testimony was that the victim, Mr. Parker, was screaming out, was crying out. That the perpetrator, Mr. Johns, was saying, this is what I do best. and making some very profane statements, which were probably the last thing that Mr. Parker heard. So those were evidence that the man from 7 feet away, from probably closer than I stand to this court, had the opportunity to see two men, roughly 400 pounds between them, one struggling for his life, over the top of that seat with his head, fighting to survive. And
This could be an issue of credibility that the jury resolves.
very much so, Your Honor. And indeed, this court has held that gross negligence in Rose and in Kiesling, which are cases cited in our papers, is indeed an issue for the jury, is a question for the jury. And when we get to this level, the test is that any evidence, however slight, after interpreting everything in favor of the plaintiff, can suffice. And that's the test really that's here before the court.
All right, let's assume for the moment, Mr. Hansel, that we agree with you that the finding of the jury of gross negligence should stand, as the Court of Special Appeals said.
Yes, Your Honor.
Where does that get you within the framework of public immunity and public duty?
The next question is one of public official immunity and whether or not there are sufficient circumstances in this case to defeat it. The answer to that is a simple yes. This court has held previously in the Williams case, in the Lovelace case, in the Lee versus Klein matter, the public official immunity is defeated by a special relationship. There's a special relationship here in 3 different ways. Number one, there's a special relationship if the jailer has in his direct custody the wrongdoer. Number 2, there's a special relationship if the jailer has in its direct custody the victim. And number 3, there's a special relationship if the jailer puts someone in harm's way.
Have there ever been special relationship cases involving one prisoner injuring another?
I don't think in the context of prisoners, Your Honor. There have been police officers. So, for instance, Williams was a police officer case. I think it's important to also...
But it was not one police officer injuring another.
No. It was a police officer was the alleged grossly negligent
Even
party.
out of state, have there ever been special relationship cases where one prisoner injured another and the officer or the guard was held liable?
It's addressed in the restatement, and I can't tell the court what. Typically, the restatement would suggest to me they usually rely on an out-of-state case.
The examples in the restatement are nowhere anywhere similar to a prison context.
But I think this case, I think this context is more egregious, not less, because both the wrongdoer and the victim are under control of the officer. In other cases, the officer either has control of the wrongdoer or has control of the victim. Here, his degree of control over the situation is higher.
Well, what if they're rather than being in a van going to court, what if they're in the prison generally? Can a special relationship be established in the prison?
It's a facts and circumstances question, Your Honor. So I think we'd need more detail. But the test is he within the direct supervision of that particular officer? In other words, we're not talking about the warden in some office downtown.
Mr. Hansel, that's true when you have tiers.
Correct.
And you have individuals on tiers.
Correct.
Who are supervising the inmates.
Correct.
That's true when you have inmates supervising inmates in medical centers in the prison. That's true when you have inmates being supervised by people other than wardens in the cafeteria.
But that's just the first part of the test. In other words, there are at least 2 more parts. Next.
Well, but you can concede that they have supervision over the inmates under that test. You said it was fact specific.
It is.
Okay.
But I think so. The first part is often met. Correct. Right. But the suggestion by the defense that this holding would in some way open up liability for any prison guard is not true.
And why is that?
And here's
not true?
why. Here's why. The Maryland Tort Claims Act protects all state employees from liability for anything, personal liability, for anything except gross negligence or malice. So the test would be, is someone in your direct supervision and custody, number 1. Number 2, have you committed as the officer at least gross negligence or malice? And if both of those tests could not be met, there would not be liability. And gross negligence is a very high bar.
Well, I understand that, but what you're saying is that in almost every circumstance that I articulated, then it would go to whether the person was covered by the Tort Claims Act from personal liability. So in probably every circumstance that I articulated, then you would go to the second parts of the test.
That's
because
correct.
then special relationship would be met almost universally.
That's correct, Your Honor. And the next question would be, was there gross negligence? And that's a very high bar. And that's where the defense's suggestion fails, that this would be some sweeping opening of the door. And there's another point to be made in that regard. The fact that the defense suggests to you this is a matter of first impression, that we haven't had, as Judge Atkins suggests, prisoner-on-prisoner issue before. So this is a rare circumstance. I mean, in the hundreds of years we've been a state, if the defense is correct, this hasn't been presented. So it's not the case that this is some sweeping new change in the law. Instead, we're going to continue to require, as the legislature has seen fit in the Tort Claims Act, the relatively high bar of at least gross negligence before there would be any liability. In addition, the defense points out, there's a question to form a special relationship of what the officer knew. Did he know that the individual was some particular danger? In this case, Cooper knew that this man was a supermax inmate. Any officer on the bus could look at him and know that because he had waist chains, which only supermax inmates had. Cooper testified at 774 and 75 that he knew he was a supermax inmate. Even setting that aside, even if Cooper knew nothing of the man before the 10 or 15-minute attack began, once the attack begins...
How do we know that it was 10 to 15 minutes? Was there testimony?
That was the approximate length of the bus ride and the changing of the seats. Yes, the testimony was from that, during the period of time when the attack occurred, was 10 or 15 minutes. I don't know
But the attack itself did not.
We don't know. We don't know.
That
That we don't know. The period of time when the attack occurred, Your Honor, I'm sorry if I misspoke, but the window for the attack, for lack of a better term. But the way the attack is described, it obviously took some significant period of time. A man has to stand up, wrap his arms around another man's neck, pull his head up over the seat, choke him, let him fall, believe he has been choked out, is dead. He makes guttural noises that are heard by people on the bus. The victim at one point screams out. The attacker at one point says, "This is what I do best," and makes his profane comments. He then, the gentleman begins to move. There's a change of seats, which the officers observe and do nothing about. He then starts to cut him with a razor blade.
Is not inherently dangerous.
Well, I would suggest that it is, Your Honor, when you're dealing with supermax inmates, and that's probably why there's a regulation that precludes it.
Well,
because it may well be.
The regulation doesn't preclude two supermax inmates sitting in the general area.
Actually, they were supposed to be segregated. That's another issue in this case. They were supposed to be segregated separately in the cage. So in the first instance, the testimony was, yes, they are supposed to be in a different place.
Segregated in the cage together, though.
Yes, correct. Away from other
really
people.
Go at each other.
Well, Your Honor, that's what the regulation provides. If I wrote the regulations, they might be different. But that's what the regulation provides.
Mr. Hansel, I know Ms. Bernhardt spoke to this a bit as well, but I'll ask it again. What was the scope of the duty of Sergeant Cooper in his position as, what was it, supervising officer?
Officer in charge.
Officer in charge. Is that in charge of the other men or special, to use the term, a special duty owed to the inmates as opposed to what his responsibilities were to supervise his fellow officers? Maybe that isn't it at all.
The best brief answer I can give to that is all of the above. He was charged with looking at the bus. He was charged with making sure the inmates were properly chained. He was charged with making sure protocols were followed by the other officers. He was charged with making decisions about how they would get on and off the bus. So basically, as officer in charge, this is a paramilitary organization. They report to each other the way people do in the military. He was in charge of everything and every man on that bus. That's the best answer I can give you.
Okay. And so to take you back a half a moment to your description of what actually ensued in this attack, there was testimony of the other inmates, I assume, as to that description?
Yes, sir.
And argument was presented to the jury on those points?
Yes, sir.
And the jury's verdict suggested they believed that?
Yes, sir. Yes, sir. Absolutely. And this court's precedent suggests that the jury's verdict should stand if there's even a scintilla of evidence, and in this case, There's substantially more than that, and we only got partway through it. I mean, there was enough blood on the back of one of the seats that the state's investigation found that it was obvious an attack had occurred. The state's recreation was that under various lighting conditions, the attack was there to be seen by the officers and could be seen.
That the blood could have come either from the murderer or from the victim. Is there evidence that the murderer also cut himself in the process of cutting the victim?
There was evidence that there was blood all over both. I don't recall if there was evidence that the murderer cut himself, and I apologize for that, but I know there was blood all over both.
I think there was.
Yeah, that's very possibly the case, Your Honor. I want to touch on another point as it relates to public official immunity, which is this court, in addition to the special relationship, has also found that public official immunity is defeated by gross negligence. And any other finding would turn Maryland law on its head.
Which case is that?
I'm sorry, Your Honor. Court of Special Appeals. Hines versus French, 157 Maryland App 536. Callahan versus Bowers, which is 131 Maryland App 163. And Artist versus Cyphers, 100 Maryland App 633. Those are Court of Special Appeals. That's it.
157 Maryland App, what?
Artist versus Cyphers was 100 Maryland App 633. Callahan versus Bowers, 133 Maryland App 163, and Hines versus French was the 157 Maryland App 536. The other states who have so held are Delaware, Idaho, Michigan, Montana, Missouri, North Dakota, South Carolina, Tennessee, Texas, and Virginia. Every state I could find that had considered the issue has found gross negligence to be an exception to public official immunity. And under the particular legislative scheme of this state, it is a necessity under Article 19 of the Maryland Declaration of Rights for this reason. Under the Maryland Tort Claims Act, there is liability for negligence on the part of the state. There is liability on the part of the officer for malice. But the Maryland Tort Claims Act immunizes the state, the government, for liability in the case of gross negligence. If public official immunity also immunizes the officer, which is what the defense asks you to hold today, for gross negligence, then there will be an absolute defense to all tort liability by a government employee of gross negligence, meaning there will be liability for negligence, liability for malice, but right in the middle, in that space between the two for gross negligence, there will be no liability at all on behalf of either the officer or the government, because the government is protected by the Maryland Tort Claims Act, and if the defense is correct, the officer is protected by public official immunity. So we'll have the absurd position where the officer can come in, and the state, and offer the jury the absolute defense that he was grossly negligent. And then the plaintiff has to come in and argue, no, he was just merely negligent, it wasn't that bad, or he was malicious. But please, ladies and gentlemen, don't find that he was merely grossly negligent, which falls logically right in the middle.
So it's your position that a majority of out-of-state jurisdictions allow the immunity, the common law immunity, to be defeated on a showing of gross negligence?
The ones who have considered it. So those states are, it's not a majority of other states, because a majority of other states haven't considered it. But yes, Your Honor.
I meant a majority of the ones that have considered.
Correct, Your Honor. And those states, again, and it's in our brief, are Delaware, Idaho, Michigan, Montana, Missouri, North Dakota, South Carolina, Tennessee, Texas, and Virginia. So the question is, will this court here in Maryland offer as much protection to its citizens as Texas, as Virginia, as Tennessee, as South Carolina, and those other states I mentioned?
Does the evidence reflect what material the protective cage was that Scott and Cooper were in?
I know it was metal. I don't know beyond that. I don't know if it was pot metal or steel, but I know they're in a metal.
I mean, was it like, do we know whether it was like chain link fence around it?
I don't know, Your Honor. I've seen pictures of it, but I can't tell you. They weren't good enough for me to answer that question.
But it was porous. They could see through.
Oh, absolutely. The purpose of the cage, it was designed and built for observation. It's in an elevated position. They're facing the inmates, and the purpose of it is to observe. And the regulation was that they're to maintain constant observation at all times. Their only job is for two men to sit next to each other and observe a 20-foot bus. This happens about at the end of that table from where I am, 7 feet away.
So there's nothing you see from the construct of that cage that would impede hearing.
No. Oh, absolutely not, Your Honor. And there's been an argument suggested that a prisoner at some point moved to obscure the view. That's an argument that arises on appeal. It was not made with any force to the jury, and there's a reason for that. Because if you look at pages 1653 through 1655, where that testimony arises, we find out that by the time the prisoner moves to try to obstruct the view, Johns had already made a seat change. He had already stood up and pulled the victim, Mr. Parker's head over the seat. He had already choked Mr. Parker. Mr. Parker had already screamed. He had already made a second time that he stood up, and he had already produced the razor blade to begin cutting him. And it was only then that the inmate changed seats to attempt to block his view. And critically on that point, when Officer Cooper was asked, how is it that this could possibly have occurred, this murder, these two men in this life or death struggle 7 feet from you, how could that have happened and you missed it?
Well,
he didn't say that anybody was blocking him.
Mr. Hansel?
I'm sorry.
The judge's
Thank you.
It's not exactly like looking at that table because you have the backs of the seats.
You do, Your
And
Honor.
it was 4 a.m. in the morning. So it was not uncommon, as I understand the facts to portray, for the prisoners who were traveling to be slumped over asleep.
That's correct, Your Honor.
So could the officer, is there real evidence that the officer in the cage could see over the back of the seat to see what was happening to a slumped over?
He's required to maintain observation the whole time, and the cage is elevated. So he's looking down over, so in other words, yes.
I understand that.
He
It's
has
elevated enough to see over the backs of a seat when you're trying to look at a prisoner who is slumped over.
I think it's a matter of degree, Your Honor, and so it's a hard question for me to answer. But it is better than sitting level and with a seat back in front of you to be elevated. And so that's the best answer I
Do
can
you
give.
know how many feet it was elevated?
We don't, Your Honor. It was elevated for the purpose of observation, however. I can also tell you this, that the blood that appears is on the top of the seat, that he's pulled back, his head's pulled back over the top of the seat.
I could not find that language that says his head was pulled back over the top of the seat. Did you find it?
I did see it, I think in E654. I think you had us look at 650.
I have 53 to 55 in my notes.
Excuse me. Yes, I did. I'm looking at the bottom of 654. And then it's a little hard to discern. Who's Mr. Gordon? Who's Mr. Gordon?
It's counsel, Your Honor. I'm sorry. That was
Okay.
counsel.
First, as you know, and then there's a lengthy this and that. And is he at the bench? I can't discern because anyway, in any event, there's something beginning at the line 24, but here's the key language in the case. The court held that a letter to the employee, oh, no, that's something else.
Yeah.
No, that's something, okay. But I did see.
Oh, I'm sorry. I said 650. It's 1653 and
Thank you.
1650.
Okay. No, I misread something. That's a big difference. We're 1,000 pages off. But let's see if we can find it.
Well, Your Honor, I've been
1653.
to 55.
Thank you.
Here we go. On page 1654, Your Honor, at the top of the page, and it's continuing from 1653, the defendant stood up and used his arm to hook the victim and pull his head back over the seat in front of him and keep pressure on him the whole time and choking him out.
Okay, and who's the witness is Patrick Cook.
Yes, Your Honor. And
that is?
He's an inmate who was on the bus.
But it was, okay.
So this is an inmate, Judge Adkins, instead of being elevated, who is seated down, where it's harder to see over the bus.
That's critical evidence.
So the fact that an inmate seated down with that seat up in front of him could see, and the officer seated up above with a duty to observe, suggests that he can't and doesn't give us any reason why.
Well, now, Ms. Bernhardt will for sure clarify or correct me on rebuttal, but I understood Ms. Bernhardt not to quarrel with the evidence, but to quarrel with the issue whether this was mere negligence as opposed to gross negligence.
I think that's largely the position she's in, Your Honor, yes. But that is ultimately an issue for the jury, and this Court's held that repeatedly, especially in cases that involve intent and state of mind the way gross negligence does. So if we look at the definition of gross negligence, it largely involves what was between the officer's ears. What was he thinking? What did he know? When and why and how? And that is information that is unique to be determined by a fact finder, by somebody who sat and watched, and we trust juries with that job.
Mr. Hansel, was there any indication in the record where Mr. Cook was sitting in reference to the incident?
I'm sure there was, Your Honor, and my recollection is that he was behind, but I can't remember how many seats. So he would have been between the officer who was elevating and observing and the victim and the attack.
So
Yes, sir.
if we disagree with the Court of Special Appeals that there's a special relationship, your pathway to success is gross negligence is enough to defeat
Correct.
common law public official.
Correct. And if that fails, then I would suggest to you the Constitution requires it, because Article 19 guarantees a remedy. And if gross negligence is not sufficient and if special relationship is not sufficient, there still has to be a remedy for gross negligence. There's a remedy only for negligence and for malice if the defense is correct. So we're stuck in this Alice in Wonderland situation where mere negligence is remediable by the state up to $200,000. Malice is remediable from the officer in an unlimited amount. But in the case of gross negligence, there's no liability from anyone. And indeed, that's where we'd be in this case, because Cooper, to date, has paid nothing. And so far, if the court were to agree with the defense, would owe nothing. And the defense suggests you're not faced with that here because the defense has paid the $200,000 on behalf of other individuals. But we are faced with it here because Cooper has paid nothing, and the plaintiff, with a judgment against Cooper, is entitled to redress. And there's the precedential effect of this court's decision here, which would ultimately mean that there'd be no liability for gross negligence. So even if the special relationship or gross negligence alone were insufficient, as a backstop, there's Article 19. And I will put, as a footnote to that, I will suggest that the court should consider the statutory scheme in the Tort Claims Act. The Tort Claims Act says, in essence, and I'm paraphrasing, that the officer individually is liable for gross negligence or malice, and the state is liable up to the cap or limitation for mere negligence. What would that language mean if, in every instance, the officer was protected by public official immunity from gross negligence? You would be writing the Tort Claims Act out of the law. It would be meaningless to say in the Tort Claims Act that the officer is liable for gross negligence, as the legislature has, if this court were going to say that, but under the common law, he isn't. So as a further
So
backstop,
does the statute supersede the common law?
I don't think so, because I think the common law has gross negligence as an exception and has special relationship as an exception.
So you
But if the court disagreed with me, then yes, then the statute does abrogate common law, and as the legislature has every right to do. So in the first instance, the special relationship defeats it. Defeats public official immunity. In the second instance, gross negligence defeats it. In the third instance, Article 19 would defeat it because we must have a remedy for that gap in the middle. There must be a remedy for every wrong under Article 19.
But he still gets his $200,000.
Not from Cooper. He hasn't gotten anything from Cooper. And in the next case,
You have a remedy for the injury.
but in the next case, maybe there's only a finding of gross negligence. So is this court prepared to set the precedent that in the case where there's a finding of gross negligence, there will be no recovery at all because of public official immunity? And yet in the case after that, that's mere negligence, there's a recovery. And in the case after that, that's malice, there's a recovery. And that's the circumstance that the defense avers for. That's what they're asking you to do. And it would literally turn the law on its ear. And that's why all of these other states have not held that way, have recognized gross negligence as an exception to public official immunity. It's why the legislature wrote the Maryland Tort Claims Act to hold officers responsible for their own gross negligence.
Do you have anything from the legislative history on the Tort Claims Act on that?
No. What the legislative history shows on that point is basically nothing. In other words, there's no suggestion that the legislature was intending to abrogate public official immunity. Now, why do I think that's the case? I think it's the case because gross negligence has always been an exception to public official immunity, and the legislature needn't have said, we're going to abrogate it because it was always there.
Do you know whether it was modeled on another tort claims act?
The Maryland Tort Claims Act and the local government Tort Claims Act were modeled very closely on each other, and there are Tort Claims Act in different states in the country. I don't know who came first, but it wasn't us, I can tell you that. And I'm not aware that there is any legislative history in any of them to suggest that the court was abrogating any part of public official immunity, but I'm suggesting to the court that's because they needn't have said that, because at the time, going back to Cyphers in '94 and the other cases I cited, which I think at least some of which are earlier, the gross negligence was already an exception to public official immunity. So I don't. It would be inconsistent to say that we're abrogating any part of public official immunity when gross negligence was already an exception, and that's why I think. But I'm suggesting that if there is a concern by the court on the other argument, in connection with the other arguments I've made, then as a backstop.
What would be your, if you had your druthers, and I'll ask the same of Ms. Bernhardt, if I forget, she'll tell me, the final paragraph of this opinion?
The final paragraph of this opinion, I think, should recognize that the court below is affirmed, and it should send the case back for entry of judgment.
Well, but give me more than that.
Well,
what's the sentence that leads us to that final sentence?
I think in this case, it would be the simply,
what's the rule that you want?
Sure.
Assuming that we get there. But
I think the rule I want is the rule that already exists, which is that public official immunity has a number of exceptions. There are a number of exceptions in this case to public official immunity, the first of which is that there is a special relationship between jailer and jail. The next of which is that gross negligence is an exception. The next of which is that even if that wasn't the case, Article 19 would require.
Well, you'll know where does an opinion go to say it's this and it's also this and it's also this and it's also this.
Then your easiest path to justice here, Your Honor, is to affirm the court below and to recognize that there is an exception for public official immunity for a special relationship, and to recognize, as the court below has and as this court has many times, that gross negligence is a question that we're going to trust to the juries of this state.
If we say that gross negligence is an exception, what impact would that decision have upon the prison guards in a high security prison?
In my opinion, none. Because in my opinion, it's already the law. The legislature has enshrined it in the Tort Claims Act.
Well, let's assume it's new law.
Okay.
I mean, what are the practical applications of that?
And be succinct, counsel.
Sure.
Be succinct in response to the judge's
I think
question.
it's a very high bar. So I don't think there is a parade of horribles here where it would expand liability. I think gross negligence is a very high bar, and having argued it in the courts of this state for 17 years, I'll tell you, it's tough to achieve. And so I don't think it would change much.
All right. Thank you, Mr. Hansel.
Thank you, Your Honor.
Ms. Bernhardt, where did Mr. Hansel go wrong in his proposed
many
findings?
places, Your Honor. And I'd like to start with his representation that this court would be joining legions of other courts that have established gross negligence as an exception to public official immunity. In fact, this court would stand alone, as far as I've been able to tell. All of the cases that he cites are Tort Claims Act cases, like the Maryland Tort Claims Act, which have exceptions for gross negligence. But public official immunity, as this court has made clear, it's a common law doctrine, and the Tort Claims Act did not displace it. They're different. It has a different test. It only applies to public officials, not to state employees. It only applies to discretionary decision-making. And I think this case really shows the effect it would have on correctional officers. I mean, look at the size of this judgment. And if you look at the evidence in this case, you can see that there was discretionary decision-making going on. Maybe some wrong decisions were made. There was, inattention. There was negligence on the bus. But there are gangs in the prisons. There are inmates attacking other inmates. This was not the first inmate attack. I mean, Mr. Johns had been convicted of killing his cellmate unbeknownst to the officers on the bus. And officers and public officials deal with discretionary decision-making on protecting inmates and maintaining order in the prisons every day. And not only that, they deal with suicide prevention, they deal with responding to emergencies. There are many discretionary decisions that are made in a highly dangerous environment. And the public policy of this state is that when public officials are making decisions like that, they have discretion. And to enable juries to second-guess discretion in this manner means they really don't have any discretion at all.
Ms. Bernhardt, how do you respond to the argument of opposing counsel that to hold with the state's position here would be to create a gap? So that if you'd have liability for mere negligence, liability for malice, but...
Well, that's a legislatively created gap, Your Honor.
Do you acknowledge a gap?
Under some, not in this case, but in some circumstances, there will be, and that's the nature of immunity, is that it bars liability. I mean, that is the nature of immunity. So, for example, in the Muthu Kumarana case, the 911 case, there was a public duty doctrine, and so there was no liability. And that didn't deal with immunity, but that dealt with the public duty doctrine. But any time you have a public duty doctrine bar or an immunity bar, it bars recovery. But that's a legislative policy decision in this case, in this situation, because as I mentioned before, there's two public official immunity statutes that cover certain public officials, and then there's the common law. And the legislature has made the policy decision that under certain circumstances, non-malicious discretionary acts of public officials, there is immunity and there's no recovery. And the Maryland Tort Claims Act covers a different, has a different construct. It's state employees in general.
What's the logic behind that gap?
Well, it's not really a matter of logic, Your Honor, it's a matter of policy. And the policy is this, that when public official immunity arose, the state had sovereign immunity and there was no Tort Claims Act. And the policy decision was made to grant certain public officials immunity. Other employees didn't have it, and the state was immune. And then the Tort Claims Act was passed, and the legislature again made a policy decision on how much of the state's sovereign immunity to waive, and it's a limited waiver. And that was a policy decision made by the legislature. And it does leave...
that gross negligence gap.
It does, Your Honor, but for certain discretionary acts by public officials.
Where do we find the expression of that legislative policy? That the legislature said, yeah, there's a gap there, but we want it there. We intend for it to be there.
Well, the policy is in what the provisions of the limitations on sovereign immunity. I mean, there's a gap in recovery by having...
Where in the legislative history do we find that? Where the staff has done an analysis of a bill and said, you know, this creates a gap here, and they go, eh.
But, Your Honor, it didn't create a gap. In other words, it provided recovery where it didn't otherwise exist. It's a limited waiver of sovereign immunity, but it didn't create a gap.
Did they consciously do this, or did they just fall into it?
Well, I think that it's not really a gap, Your Honor, because what you have is public official immunity, and the Tort Claims Act is just dealing with the state's immunity and the immunity of state employees. And so they're dealing with two different topics. You know, public officials aren't just state employees or state officials. It can be local police officers. It can be any a law enforcement officer that exercises part of the police power of the state or the sovereign power of the state. It doesn't have to be a state employee. And so they're really two separate
so there's no
areas.
There's no direct answer to my question.
There isn't, Your Honor. It's just
so
the
there's
policy.
Probably nobody down at the State House that understands that.
I can't answer that, Your Honor. I don't have the answer to that. But another point I'd like to make before I conclude is that the representations about the gross negligence already being exception finds no basis in either this Court's decisions or the Court of Special Appeals decisions. And I think we've explained in our brief how the statement of the doctrine of public official immunity is always worded exactly the same. Malice is the only exception. And that's clear in the case law. And to the extent that any case has addressed it, it has found only malice and exception, that out-of-state, in-state, it's a common law doctrine, is treated the same everywhere. To the extent that any other state has a different rule or has gross negligence as an exception to state employee or official immunity, it's a creature of statute and depends on the particular circumstances of the statute passed by that state's legislature. Many of them have Tort Claims Acts with the same basic elements as ours. And so this case really comes down to, would really require this court to overrule all of its cases that grant this immunity for discretionary decision-making by correctional officers. I did want to point out one other thing. There was a question about the prison context and special relationships involving inmate-on-inmate attacks, and there are some out-of-state cases, and they're cited in our briefs. One of them is cited in the respondent's brief at St. Julian versus State, and that was one where prison officials had actual knowledge that an inmate was dangerous. The other inmates had been begging for protection from him. He had a knife, and he ended up stabbing one of the inmates, and they found that created a special relationship, but that the way in which they respond is still a discretionary act that can be covered by public official immunity. And then Shivas versus Keeler, also cited in our brief, said that established a test for showing a special relationship and said that you have to show that there's a particular special relationship between the defendant officer and the inmate that's different from the relationship of the inmates at large. So it sort of takes the prison and treats it like you would do with the public and look at the relationship. Has it focused on that particular individual, or is it a public? Is it the same to all the inmates? And then one other case is Western Virginia Regional Jail and Correctional Facility versus AB, which is cited in our brief. And again, that was one which said that there has to be some special knowledge of danger to that particular inmate. There has to be some particular reason to know that, seeking out protection or reason to know before there's a special relationship. So they're analyzed basically the same way. It's not just because of the custodial situation that creates a special relationship. That really just creates the public duty for the care and the keeping of the inmates that the case is recognized and that this court has recognized. But when you're dealing with attacks, inmate attacks, or the provision of medical care or suicide prevention or any of the many discretionary acts that correctional officers and public officials make, that they are entitled to public official immunity for their non-malicious acts that are performed within the scope of their official duties. And in this case, the undisputed evidence shows that the officers thought something was going on. They made decisions. They may have been the wrong decisions, but they were discretionary decisions. They were made about the care and keeping of inmates, which is in relation to a public duty, and that this case would have broad implications for the state's correctional officers if this court were to determine that any time an officer makes a discretionary determination, that a jury can second-guess that and impose a substantial liability for a wrong guess. And so we'd ask the court to reverse the decision of the Court of Special Appeals.
Thank you. Thank you. Thank you to both sides. Well-argued case. The court will take a brief recess and expects upon its return to have parties in number 74 State versus Westry at counter table. All right.